us. You got a lot of great speakers lined up in presentations and breakout sessions over the course of the next few days. And also want to acknowledge, I don't know what they call it, there's a tribal chief or Grand Chief Judy Wilson. Just Judy, all right, just Judy's with us. Judy Wilson visiting from BC, and a number of other leadership from across the country are with us here too today, but I want to acknowledge her work that she's done nationally on the child welfare file. And Cindy's going to talk about that this morning and give us a really good update. And I want to acknowledge our directors table here. I want to acknowledge our technical advisory group, which is made up of all of our agency directors, for being so central and integral to work alongside Cindy Blackstock. And of course, Raymond Shingus, who just recently retired. I can't believe that guy's actually retired now. I was thinking about him this morning. I was thinking, my God, it's probably the first month-long vacation he's got in 50 years. And Raymond Shingus was one of the key players. Marlene Bugler, one of the last standing old guard that started all this work. Vera Says, another one to PBCN director. Lionel Bird, who retired too as well recently. I keep telling Marlene and Vera they can't retire yet till I retire. And then after that they can leave. But there was a number of people that were key and instrumental along the way that worked with the Caring Society to get us where we are today. And I know FSIN takes a lot of hits out there all the time, and what's our purpose and what's our role. But the FSIN has been central in a lot of this work that's gone on over the course of the last few years in terms of child welfare reform, as well as the compensation. I remember, Cindy, a few years back in December, when we had to work so hard with Justice Murray Sinclair, and how the AFN in Canada at that time had negotiated a compensation agreement that excluded a number of people and did not make 40 the floor. And if that resolution had passed the AFN Assembly as is, Jordan River Anderson's own family would not have been eligible for compensation underneath that resolution. Also, it would have excluded caregivers, it would have excluded estates, and it would not have guaranteed that $40,000 per child would have been the floor. But thanks to the hard work and efforts of Cindy Blackstock, many other chiefs at that time, who are too numerous to mention, we were able to come to a resolution with Murray Sinclair that covered everybody. And now those resources are rolling out the door, over $20 billion package that covers our children that were hurt by the child welfare system and taken away unnecessarily in many cases and suffered trauma within the system. So I want to acknowledge Cindy for leading that work as well as our tag table. So let's give them a hand clap and recognize them this morning. So there's been a lot of great work that's happened over the course of the years, and I want to acknowledge how central our role, as well as the other regions. Mary Tiji, I heard she's here, but I don't see her. But Mary, as well as Richard Gray from Quebec, and a number of other leaders across the table at the NAC, the National Advisory Council, at the AFN, that worked alongside Cindy too as well to get us where we are today. So there's a number of people that have not only played our central role regionally, but even nationally, to have fought for our kids. And Cindy's going to talk more about that. I don't want to update on the CHRT. She'll update you all. She'll update you on all the good work of the National Children's Chiefs Commission work. And our regional representative, I'm very proud of her advocacy and her work, is Chief Erica Bowden from our region, is our representative at that table, and has done very well working alongside Cindy and pushing the table to get a good final settlement agreement that truly stops discrimination against our children once and for all. So I acknowledge them today. So it gives me great honor this morning to introduce our keynote speaker, and that is Dr. Cindy Blackstock of the Caring Society. So let's join me in welcoming Cindy and giving her a big hand clap. Ray asked her if she should read her bio, but I think all of us have been fanboys and fangirls. We know everything about Cindy already.
Thank you,
Thank you, Cindy. Welcome. God bless you. Yeah. Let's give her another hand.
So it's a great honor to be here on Treaty 6 territory, and thank you, Vice Chief, for all of your advocacy and standing with the children and never wavering. It's been appreciated, as has the advocacy of so many leaders and so many experts across this country, the ones that were here before and the ones who are right here in this audience ready to take my place. And I'm excited that you're here because the children need you. And that's really what this little bear is all about, is that we have to fall in love with the children enough to say no to ourselves, no to each other sometimes, and no to Canada, and no to the province. But we also need to know when to say yes, to move forward in the darkness even though we don't know what the next step might bring, and to trust in the ancestors, the children, the facts, and in the people on the ground who are already working so hard with our families, that they have the answers, and that will do the right thing. Self-determination is interesting. I hear a lot of people talk about that's where they want to go. And I want to go there too. But like most things that are sold off as shiny pennies with no faults, I've learned to question those things the most in my life. Because those are sacred things. Self-government is a sacred thing. It's about making choices, about honoring our ancestors. So we have to question. We can't just say that it's the destination. It's not the destination. It's a tool. It's a tool for us to do better by our kids. So we have to make sure what we're doing will actually do better for the kids. It's not about signing something. One of the best negotiators I know, and I've had the pleasure of seeing many, said, the test of a good agreement is the day after the lawyers have feasted. And I think that's right. What are the children going to experience a day after all the celebrations are written, signatures are on the plate, and everything else? I begin talking about colonialism because I've been thinking a lot about how it's affected me. What are the choices I'm making that might reinforce a different outcome than everyone else? And we all have experienced it and been bathed in it, and we've seen the consequences in our families and communities up until today. But a definition I like is one by Eduardo Galeano. It says colonialism can be the obvious stuff, like the theft of our lands and its residential schools and that kind of thing. But the more dangerous stuff is the invisible colonialism. The colonialism that convinces us that serfdom is our destiny, that impotence is our nature, and it convinces us that it's not possible to speak, not possible to exist, and I would say not possible to dream. It also makes us really excited when we're meeting with ministers and prime ministers. I say, why? They don't do anything 90% of the time. Right? You know, like, why get excited? Sometimes they will, but not very often. So I've been thinking this through. And when I think about colonialism, I think that it really separates and dehumanizes. I'm really scared in this world when I hear people say them and us, and the us is always the better side, and we're seeing that all over the world with people suffering. And those people who think that they are the better people, they don't realize that they're gifting away their humanity in that process by dehumanizing and debasing other people. It also talks about the normalization of it, how normal it is. Those things where we get into relationships with government, relationships with our own selves, our own thinking, and we've always done it that way. And we don't even question why we're excited about going to see the minister, right? It's just like that's supposed to be there. That's the way we do things. So for me, it's about looking at the obvious things I do without question and questioning those more. And it ingrains languages in us as well. Like I find, and I know that this might be controversial, but the word indigenous is overused. It's overused because it doesn't respect the individual, diverse, and distinct nations we have, the differences between our nations, and the differences with other Indigenous peoples around the world. And one of the other things they often do, and this is in the playbook, is the old divide and rule thing. They're doing that all the time. And I am so grateful to see so many leaders reject that now. That there's so much awareness and good leadership that just says, no, 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 we see that coming. No, thank you. But it is something that is still actively used out there. And this disabling of resistance, I'm going to get to this in a minute, where the government actually only wants to talk or really collaborate with those who think like it does. And when it gets into those spaces and there's others doing important work like the National Children's Peace Commission, that's up to all of us to step up and say, Canada, you may not be interested in funding it. And in fact, it's because you're not interested in funding it that I'm going to have a bake sale. I'm going to have some kind of fundraiser. I'm going to reach into my pocket for those of us who can spare a few dollars and make a donation to the National Children's Cheese Commission. Because they're doing the work for the right reason, and that is this little bear and all the children that bear represents. The other thing I find about colonialism is it narrows my thinking. I can only see this much when our ancestors saw everything that was so interconnected. Like I look at that teepee and it's open to the universe. That's how big our thinking was, right? Across time and space. And our kids are growing up in a world where we're dealing with a lot of change around the world. This crazy nutcase in the White House is just brewing up all kinds of problems. But we have demographic transitions as people flee climate change in their areas. Our own people are moving into the cities because of lack of housing, lack of opportunity for employment in some cases, needing to get services. We also have what we're called frontier technologies. Every kid has got a phone now. And we have to think and encourage all of us to think about regulating artificial intelligence and these smartphones so that they don't become the teachers of our kids, that we're able to reclaim that and regulate that. Those are some of the conversations we should be happening, but we're always so busy at just trying to deal with the bare necessities, getting clean water, getting housing, and those are important conversations, but let's not lose sight of the bigger pieces. Inequality is one of the greater global trends, right? We're seeing more Elon Musks, and I don't know what it is, but the more wealthy they become, the crazier they get, right? It seems. So we need to kind of look at the redistribution of wealth that was always in our communities and the redistribution of power. No, in our different communities, no one person held all the power. There were check systems. That was the purpose of the clan systems, and for those people who have clans, etc. And we need to re-embrace those as part of our justice systems. So when I hear about jurisdiction, the first thing I think about is it's a tool. I don't let my mind trick myself into thinking it's the destination. And then I say, what's the problem we're trying to solve with it? And will it solve that problem on its own? It might be one of the pieces, but it's not the only piece. What are some of the downsides of self-determination? And I know that's a hard conversation to have because then the reaction is, well, you don't support self-determination. Well, actually, it's when you question things that you support them the most because you want them to work, right? So let's take a look at child welfare. I think this is a great thing to kind of focus on as a case study because I actually don't think child welfare is the major problem. And I think the problem is we think it is. And we keep on shuffling deck chairs on the Titanic by creating new tools, taking on new practices, doing all this stuff, and big changes don't happen. What is the problem? What's feeding the overrepresentation of kids in child welfare? You know it. You see it every day. It is the multi-generational trauma. People like Judy Atkinson, by the way, I just put a shout out to Judy Atkinson in Australia. She's an Aboriginal and Torres Strait Islander woman who does great work on kind of multi-generational post-traumatic stress, right? And she says, like, that not being resolved gives wake to addictions crisis. The opioid crisis is horrible out there, right? And it kind of worries me how it sometimes gets framed as a housing crisis. Well, housing might be a part of it, but that's not the big ticket item. The big ticket item is a lot of people walking around with this unresolved trauma and no place to be able to deal with that in a good way. And access, because these drugs are really, really potent, right? And the drug cartels and their dealers are very entrepreneurial. So when Canada, for example, and I believe in learning from everybody, when Canada says we can't get affordable food up into the north, and we can't get mental health and wellness up to the north, I think, well, the drug dealers have found a way to get all that crap up there, so why don't we learn from them, right? They're obviously doing it. We need to have courageous conversations for our kids. Some of our kids are suffering from sexual violence in their families and in their communities. And we need to acknowledge that, and we need to say that self-government means that we hear you and we're going to do something about it. And even though it's going to make us adults sometimes really uncomfortable because maybe that person who's doing that harm for that child is a family member, maybe there's somebody who we thought was a good person, and then we find out that they're doing these other things. But we have to do that if we're going to be self-governing. And we have to get after the poverty and poor housing. So one of the questions when C-92 came out is I actually asked myself, can you actually even have self-government and child welfare? Because when I've looked at the different nation laws across the country, and I'm by no means a John Burroughs kind of expert or Val Napoleon, I'm not in that league at all, or with Mr. Moran and his great knowledge of the law, but those laws weren't child welfare laws. They were child well-being laws and family laws, and everything was interconnected. So are we actually getting self-government in child welfare? Is that really who we are? Is that something that our ancestors would have acknowledged? And it can be. I've seen some interesting models by nations who have created their own constitutions. Then they're plugging these topic-based laws on top of that. That is a very important and promising approach because it gives you a trunk to anchor these laws onto that are coordinated. But if we're going to be dealing with trying to keep kids safely at home, by the way, numbers of kids in care is not the right thing to count. I can reduce the number of kids in care in Canada like that. Will families be safer? No. Will kids be safer? No. We can do all kinds of tricks like that. What we want are safer families, safer communities, and that creates safer kids. But we have to go after these big ticket items in order to do that. So if you're sitting at the negotiating table with Canada now, the conversation should be around trauma supports. It should be around addiction supports. It should be around domestic violence and poverty. And keep in mind that even if you're thinking about the kids, remember we talked about migration as being one of the mega trends, 72% of First Nations kids in care are off reserve. That's why Canada is so nervous, dusting up saying, well, you know, we don't want to deal with the kids off reserve because that's the majority of, in their minds, the cost. So let's talk about this case. I want to just be realistic because I hear a lot of folks talking about the case, and I want to honor everybody who was there from the very beginning because it was always a collective effort, so much a collective effort. But the tribunal case is about ending Canada's discrimination in child and family services, ending in Canada's discrimination in Jordan's principle, and making sure it does not happen again. That's what the case is about. It's not about agencies, it's not about First Nations being on the hook for stuff, it's about Canada's accountability. That's why when they use the word long-term reform, it's not about child welfare reform. In my view, Canada should have no part in child welfare reform other than funding it properly, because it's clearly shown that it doesn't know how to look after our kids other than by hurting them. So reform needs to happen at a nation level and a community level. What the case can do is stop Canada's discrimination. And it should not matter if you are under your own jurisdiction. Canada cannot discriminate. It should not matter if you prefer to use the delegated model. Canada cannot discriminate. It should not matter if you choose to get the services because Canada funds the provinces. Canada cannot discriminate. And our job is to hold them to that now. Because the tribunal's already done its job. It said, you cannot discriminate. It's a legal order against you. The question for all of us is, are we going to be willing to do what's necessary to hold them accountable? And many, many, many of us are. But more could do that. Now, here's another way that kind of colonialism kind of manifests in my view. So we're at a crossroads. This is a legal case with ongoing proceedings. So if Canada doesn't come to the table, that's not the only way of resolving it. It's not in their hands. They still are held accountable to these orders. Well, do we want them to come and negotiate in good faith? Yes. Do we want to come to the table and just blow smoke and not do anything? No. So negotiations need to be clear about what we're trying to achieve, and they need to be done in good faith. That's one way, and the preferred way to be able to resolve this complaint. The other way is litigation. And frankly, people say, well, we want to resolve this outside of the courts. Well, we've been at the courts now and the tribunal. I think we're up to about close to 35 different rulings from the tribunal and the courts. And the kids have won every single one of them, except for one that was overturned on appeal. So that's a pretty good batting record. So you have got things like Jordan's Principle Off Reserve, capital, prevention services. All of that was from court orders, not from voluntarily Canada coming to the table and saying, we'd like to do this for you. So that's important to mention, is that we can litigate, and the kids have been successful at it. In the age of reconciliation, do we feel we should have to litigate when this is the top call to action? No. But you know what? If we have to safeguard our kids, then we're going to do it, right? Because it's Canada choosing to litigate with us. We could also do a combination. Okay, so let's talk about what I've seen as some of these patterns, and you probably have your own list, and maybe we can begin a conversation. But what I see is that they foster a deep love in a tool. They want us to love the tool. And so when they pass legislation, they give, like UNDRIP, some kind of recognition, but there's nothing there to enforce it. That's kind of like the modus operandi. Control through funding regimes. Remember Dean New's book, Accounting for Genocide? If you haven't read it, go out and find a copy at your bookstore. That is really how things get really done, is these funding agreements, the terms of the funding, the level of control that the department has. Segmentation. This creating of, like, we have our education department, we have our health department, child welfare department, and they fund them separately. That's why those silos exist, versus a true kind of holistic wraparound service. Entrenched tools, they're great negotiators. I have to give them credit. I mean, they are really good negotiators. They sit across the table, they come with a key piece, they will give you the moon and back. And, but it's like when you have to read the fine print, as leadership did in Calgary. The first 150 pages sounded pretty good. We're going to pay you this, we're going to pay you this, we're going to pay you this. And then you get to that 1 or 2 paragraphs where it makes all of that in their discretion, right? So, like, that's how they negotiate. And they put big money up there, right? Like, here, come here, you sign this, and you can get this money. But then when you read this fine print, it's like, well, you can get this money if we decide to pay you this money, right? And only if you get these conditions. We talked about divide and rule, and then sometimes they will get a few ambitious people to sell it on behalf of Canada. That also is part of their modus operandi. And the thing we have to be cautious about is their interpretation of self-government often looks like offloading. And I want to credit Chief Baudin for being really honest about being on the other side of C-92 and just cautioning everyone about what are some of the downsides that we need to watch out for and what are some of the good things that are out there, right? So I actually think that negotiations can be useful, but we have to be very strategic. And I'm starting to learn more from our leaders about this, because I'm not a natural negotiator. I don't think, what is there to negotiate about when you're talking about kids' childhoods? Aren't we going to do the best we can for them? But they do stuff. They will delay. They will take it back. We've got more questions for you. And they also want to negotiate with First Nations in darkness, but they're holding all the cards. They know what's happening at every single table, right? And they control who they negotiate with, and this becomes important for the National Children's Chiefs Commission. Now, Vice Chief Pratt was talking about this final settlement agreement, and I think that this is a case study too. So after years of not wanting to negotiate, all of a sudden they want to negotiate. And they passed the act respecting First Nations, Métis, and Inuit children. What some of you don't know is people like Mary T.G. and Raymond were working on First Nations draft legislation that actually included mechanisms to hold Canada financially responsible. Canada said, we don't want anything to do with that. We have C-92 that we're going to bring in. And then they said, well, we're going to resolve this complaint. It included, they signed an agreement in principle. The Caring Society signed that. And it included a clause where you couldn't litigate against Canada. But it also included a work plan that was negotiated with Canada for them to comply with Jordan's principle. Now I'm going to ask the room here, who thinks Canada is complying with Jordan's principle? So the Caring Society chose to step out of that agreement because we felt our primary obligation was to the children and to all of you. And we were not going to stay in an agreement that was aiming to end Canada's discrimination while we sat on our hands and allowed Canada to discriminate. But that's the kind of mechanism that was there. They breached that agreement. But then they say, well, the Caring Society left the negotiations, right? That's the narrative that's brought up. Then you have this agreement that is negotiated in darkness. The leadership and their experts see serious shortcomings. There's a clause in the agreement that asked all the First Nations parties to go out and sell it. It said, try to do your best efforts to secure the approval of leadership of this agreement. And the tribunal has to go away. That's the price of all of this. The tribunal has to go away. And no funding for First Nations to do their due diligence. Many nations did it anyway, but for smaller First Nations who are really in, dire straits, trying to meet the basic needs for community, there was no resources to hire a lawyer or meet with experts to do this. But still, leadership did exactly that, and they did in a short time for approval, right? It's kind of like the shopping channel. Buy now, there's only 6 of these left. If you buy now, I'll throw in a set of knives. But you don't want to be the person who loses out, right? That's just kind of the thing. So but leadership, I think, and its experts on the ground, were mobilized themselves when they saw the agreement. They reviewed it. They met in their, as nations, internally, and in their regional collectives. And they shared notes with one another about what they're seeing in this agreement. And that led to real free, prior, informed consent. And what I will say about Calgary is no matter what position the leader had going in there, what a beautiful scene for kids. to know that over 400 of our leaders dedicated 3 days to talk about them. That was a beautiful thing. But most of the leadership said, no, we need to do better. That we're not going to fall into this trick of seeing this big advert of the money, but in the fine print seeing that really it's they don't have to pay it, that there's lots of strings attached, new powers for the department to go in and regulate your service providers. And then the chiefs organized and said, we actually want to structure these negotiations completely differently. We want to have the National Children's Chiefs Commission. So this thing was formed by the rights holders. And I have never seen anything come together so quickly. And it's a credit to the chiefs and it's a credit to these commissioners. Each region, without any invitation, they just organized in their own processes and said, here's our commissioner. And that came together in weeks, right? Then we had folks like Our Children, Our Way stepping up and without getting paid, being willing to be the secretariat. Then we had lawyers like Scott Smith and Liam Smith standing up and saying, you know, eventually we'd like to see Canada step forward and pay, but if they don't, we're still here, and we're going to help you out. Then we saw negotiating teams and all the incredible experts. And this thing became a force, right? This is an excellent model, I think, for any topic across the country where there should be a national decision made. That ensures transparency and accountability to leadership. It also ensures the best ideas come forward for kids. There's no funding for Canada. And that brings me back to that earlier narrative. When there's no funding for Canada, then there should be funding from all of us. We can hold a fundraiser in our community. We can hold a gala to support this National Children's Chiefs Commission because what they're doing is holding Canada accountable for its discrimination now and forever. So I would ask you to add on to your to-do list that for those of you who can, please make a contribution to support the incredible work of this particular group. But what did Canada do in the wake of Calgary? Now you think that they would say, okay, we gave the chiefs a choice. The chiefs made a different choice. So let's sit down with the National Children's Chiefs Commission and see what we can work out. It didn't. It was disappointed in the chiefs' decision. And it announced it would only work with Ontario because, and I should say, and I want to say Chiefs of Ontario specifically because not all the First Nations in Ontario agree with this agreement. The vast majority do, but there are some who disagree. So they were going to work with them, and then the minister said the rest of the country isn't ready. But the National Children's Chiefs Commission clearly was ready. So now we have this Ontario agreement. We have Canada saying they are, quote, not coming back to the table. But that does, remember that piece where Canada actually doesn't control this process. It's a legal thing. And that's where we come back to the tribunal. There was a very, very important ruling issued by the tribunal last month on August 20th. And I recommend everybody read the full thing. It's 2025 CHRT 80. And what does the tribunal do in this? Well, it's saying, look, we've been at this as a tribunal. We've held jurisdiction to make sure our orders had effect for kids. Because at the end of the day, the discrimination the tribunal found was right there. It wasn't discrimination against agencies. It wasn't discrimination against First Nations. It was discrimination against the kids. So we got to hang around until we make sure that stops. But they said, look, there hasn't been a lot of progress. We've had, close to 30 non-compliance orders against the feds. So we got to figure out how we're going to deal with this. It said a couple of things. Canada wanted the Ontario agreement to inform national reform. That's why it was pushing to have it heard early. The tribunal has said, no, Canada. Whatever happens with this Ontario agreement will not affect national reform. Having said that, in the agreement itself, there is text that directly impacts national reform. So there's more work and clarification needed there. What do I mean by that? I'll give you one example. Paragraph 3 of the draft Ontario agreement says, this agreement will, unless the context necessitates, this agreement will only apply in Ontario. But there's no clarity as to what unless the context necessitate actually means. So we need to clean up that kind of stuff. But it's good news. And the tribunal also said no one party can dictate the timing of this. So Canada, we heard that you are not coming to the table. Okay, well, you don't have to come to the table. We'd like you to meet with the National Children's Chiefs Commission. We'd like you to meet with the Caring Society and AFN. But if you're not going to do that, we want to see your plan for how you're not going to discriminate and not do it again with evidence by December 20th. Meanwhile, First Nations, Caring Society, AFN, you're going to be working with the National Children's Chiefs Commission. You come up with your own plan with evidence about how to hold Canada accountable to stop discrimination and prevent it from happening again in child and family. So that's the work that we were given. And Canada's first obligation was to report back to the tribunal on August 29th to say whether or not they would meet with the National Children's Chiefs Commission and the Caring Society. So Canada did write in. They have a whole pile of clarifications about this order that they have questions about. They've also said, well, we're not going to work with the Caring Society because they're difficult, basically. And we've already had 2 phone calls with Chief Frost. So does that satisfy your order, or do you want us to talk to the commission again? That is the kind of stuff that we're dealing with right now. But nonetheless, that should not deter us. We have work in front of us to do. And I'm just going to be clear, we have no money to do it. And I also want to say I absolutely believe we can get it done. Okay? We got to come up with a plan. I underline that, on how to stop Canada's discrimination in child and family and prevent it from happening again. Just the plan, not the final thing, by December 20th. And we've done so much work across the country. Leadership has done so much work across the country. I'm confident we can do this. So, we took that order and we aligned it against the direction of the Chiefs and Assembly and the resolutions. And I think many of us were surprised to see how much it echoed. They were saying the same thing the Chiefs were saying last year in Calgary. And that's a really encouraging thing. The tribunal said a bunch of important stuff. Canada, you are obligated to stop your discrimination for multiple generations. That means not for 2 years, not for 5 years, not for 10 years, for multiple generations. They also said that their order to stop discriminating, what they call the cease order, if you read that in the actual order, it's called the cease order, is akin to a permanent injunction against Canada. So it's a permanent injunction. They can't just wave their hands and negotiate below that. They have to stop doing that forever. So for those of you who are looking at jurisdiction, I would really look at that with your experts and see how that creates a floor for you. They also said that the nations and others it's great if you improve on our orders, but you have to respect the spirit of the order. So there's that fine reading, you know how some of us, we see lawyers and they're kind of saying, well, that word could mean this or could mean that. Well, what the tribunal's saying, the spirit of our orders is about that little cub. Is that child okay? Are they able to live the life that they wish to have? We have to protect the spirit of the orders. That you just can't come with back of the napkin, well, we know better. Believe us, we have a new regime. It's all going to work out okay. That is not going to fly with the tribunal. They want to see real evidence that this is going to stop it. So, and thankfully we have it. It needs to respect human rights, the children's rights, and self-government rights. And this is something that has been kind of seeding. I'm just watching my time here. This is something that's been rather perplexing to me sometimes when I hear a conversation about, well, we can give a bit on the child rights side in order to get self-determination. And that's not usually by our people, but I just hear it in general. I don't understand that. Because the laws that I've been privileged to see are actually not even about us in this generation. They're about the future generations. So how can we be unconcerned about children now and in future generations and somehow call that self-government? I don't understand that, right? So those two things have to move together. In honoring the rights of our children, we are honoring First Nations rights, right? There is no trade-off there. Those things move together, and that's what the tribunal said. Now, the tribunal has also learned a lot about how different we are, right? There's a lot of things that are the same across the country that we have to create a floor on, but there are differences, cultural differences, language differences, differences even in the way that the department funded us before the complaint was substantiated in 2016. So they said, look, we want you to account for those regional differences. And when you come to us with a solution to address that discrimination. So we're going to be asking all of you to kind of respond to questions about what in your region is a difference that needs to be addressed in order to stop Canada's discrimination. And it's going to have to be focused in that way. Like, there are many regional differences and probably many different regional needs. But we're going to be interested in what is happening in your region that if it's not addressed, children will still experience Canada's discrimination. So, and then there's this no more waiting around for Canada. So this really supports the direction from leadership, a national agreement, or I should say not even agreement, because Canada, it's clear so far they won't agree to anything. So a national plan with regional variations. So I think that the other thing that chiefs did actually just in the the most recent meeting is some people were saying, well, we'll just have our own regional agreement with Canada. And that sounds good. But if you touch on these legal orders, you have to go and fulfill all those obligations of paragraph 113. You have to make sure that, the tribunal will even hear from you. And I think the tribunal has been pretty clear in its most recent order that it's a very small tribunal. It can't have everybody come into the courts. So the chiefs decided we're not going to pursue regional agreements right now. We're sticking with the national plan with regional variations. So we got to get busy on this plan. We're already busy on the plan, so don't think that we're starting from scratch. We're going to be coming out with, working with our experts on the National Children's Chiefs Commission that includes representatives from this territory. And we're going to have consultation documents that'll come out to you. We are going to ask that you as experts on the front lines, as well as your leadership, meet, provide good feedback on those questions, maybe a few challenges, maybe there's something we missed. All of that is good and going to be in the guide. But it'll have to be kind of consistent about how we collect the data across regions, because we got to roll it up and make sure that we're able to use it as a national plan. So we're going to get that hopefully done in the next 7 to 10 days, so it won't be a long wait. Then after that, the work flows to you. Think now about what are the meetings you have with your experts in the region. When are your leadership meeting? Let the folks know at Our Children Our Way, the National Children's Chiefs Commission, when those dates are. Because we want to make sure that we have the materials to you in time for those meetings and those discussions to happen. Then we're going to roll it all up. We're going to have a plan that we're going to send out to folks, and you're going to have a chance to see it, and then it gets filed with the tribunal. Is it going to be perfect when we file it? Probably not, but keep in mind it's a plan, right? That means by the virtue of it being a plan that we can do some more consultations and other things after that. One thing I do want to kind of star for everybody is to keep in the back of your minds is Canada was saying, if you're going to be delivering prevention, First Nations, you could, under that other agreement, you could get $75,000 as a minimum standard. And many of us, given the tribunal's direction about evidence, weren't sure where that number came from. Where does 75 grand come from? What can you do with 75,000, right? So we actually self-funded a study, and this is on our website. And this was actually something that was suggested by leadership, so I want to just credit Chiefs for asking this question. How do we ensure that small population First Nations aren't disadvantaged? And it turns out you need 1.2 million to deliver any level of prevention services. The other myth I'd like to kind of bust right now is this idea that prevention and protection are separate. They are not. They are not. They work together. And it's easy to think prevention can be over here and protection over here, but that doesn't work that way, right? One of the key things that the tribunal found to be discriminatory is child welfare gets involved when you do a report to child welfare. So the child welfare people do the assessment, the investigation, and then you need to have services there to help the family stay together. Well, that was missing. So unless there's enough services that are coordinated, and I'm agnostic about who delivers these services, by the way, but unless those services are there, then and they're coordinated and actually would meet the needs of the most at-risk families, then we could have kids falling through the gaps in the same problem that was found at the tribunal. But you need a $1.2 million operating base as a minimum to just get off the ground to deliver prevention. And keep in mind that the data shows, and you see it on the ground, our families and our kids, their needs are growing higher. We're seeing more rates of autism, more rates of families with severe addictions issues. So that's the type of prevention we need to wade in deep on. What are we hearing across the different tables about C92 and these coordination tables? First of all, Canada wants to build a firewall between itself to protect itself from liability. That's what we're hearing. That is its primary goal. And liability comes in two ways. One is financial. It doesn't want any more class actions to have to be paid out on its purse or anything like that. But also, it doesn't want the political liability, right? Pass that off to somebody else. It's increasingly wanting to enter into short-term funding agreements. So you take on the jurisdiction, and we'll give you a 2-year funding agreement, and there's not a clear answer on what happens if there's no funding or insufficient funding after a few years. It is incentivizing people to follow the C92 pathway to affirming jurisdiction versus opening up, in my view, what should be other pathways: treaty, inherent right, self-government agreements. Those should all be pathways where you're supported if you choose that that's the best pathway to go down. They also have this thing calling it subsidiary federal law. I'm not a lawyer. I have a degree in law, but I'm not a lawyer like many of the people in this room are. So I had no clue what that was. But what it turns out to be is, under the Act, it says First Nations laws would have the force of federal law. That sounds good. But it's not real federal law, like as in the federal law Canada can pass. It's federal law that's called subsidiary, which means your law would apply in your home province. If you wanted to apply next door, well, then you have to go and negotiate with that province. And even more complicated, if your law enforcement is the RCMP, under the jurisdiction, they can remove kids, right? Law enforcement in many regions can remove kids. If you want to deal with that, you have to have a negotiated agreement with the RCMP regarding that. So there's all kinds of stuff like that. And it wants fixed amounts. Now, you've heard me before. I'm not going to be a broken record on this one, but the amount of funding you get is the least important thing. Most important thing is the purpose of the funding, how it's structured, how long it's there, and what is the enforcement. Because if you get all those things right, the level will always be okay. If you get a big chunk of money and none of that, or weak or kind of questionable structure and enforcement, then that would seem like a big amount of money can go down the pot quite quickly. Many of us in this room know of children who their needs are so profound that it's $1 million+ a year for one child. And there's this not wanting to write anything down, right? Not wanting to have meetings recorded. Well, if you're negotiating in good faith, then why don't you have minutes, right? I think that this is really an important thing, is that everybody's accountable around the table, including us, but including them. That's part of good faith negotiations. Need to think about various jurisdictional models if you're going down the path. The invitation is to take it all over at once. And I can say that, you know, I've been on the front lines and on the front lines for well over a decade. And I enter into those spaces of working with families with great humility. That we need to be there at their worst moments. That means we need to build up our own capacity to be there for that family, not to have them wait while we build up that capacity. We need to do that so that we're there on day one with our people who are trained in the workforce, able to discharge their responsibilities with the resources. So we need to make sure that that capacity is there. That invites a slow approach where you're building capacity. Another one of Canada's divide and rule has been to say the agencies are the problem. Don't look at us, it's the agencies over here that are the problem. And I think that that's been an unfair criticism. It's not that agencies always do the very best thing, but all the research says they're doing far better than the mainstream systems. And these groups were created by First Nations to help build that capacity. So why not build on that capacity versus starting all the way from scratch? I'd also be careful about really thinking that law is going to fix stuff, because laws cannot fix the opioid crisis on their own. Law cannot fix the mental health crisis on its own. We're gonna need these resources, we're gonna need the workforce, we're gonna need all this other stuff. And some of you may not know this, I didn't know it, but Canada's reviewing C-92 right now. Now, most people don't know. I've reached out to Canada and said, hey, I've got some suggestions. Unfortunately, they haven't reached back yet. But that's okay. When they don't reach back, I still find a way to say something. I would like to see the tribunal's order about this being a permanent injunction to stop their discrimination actually embedded in C-92. I would like to see Jordan's principle be embedded in C-92, because what we're seeing is broad non-compliance with Jordan's principle, which again is putting us back in a situation where kids are coming back into care. Are any of you seeing that? Yeah, eh? Deal with those drivers, mental wellness, addictions, poverty, housing. Let's deal with those. Include technical and funding support to make sure this is success, that this tool of self-determination leads to a generation of kids who are better off than where we found them. And recognize that traditional family laws can cut across other types of programs, including education, including health. So how do we build that together? And I'm confident that we can build it, but we just have to ask these questions. So to me, when I look at this jurisdiction, equity in the funding, substantive equality, and people and resources are key. Those things have to move together There's probably other things too, but those are the building blocks. Funding, purpose, structure, enforcement need to be in there. Not just a 1-year funding agreement or a 2-year funding agreement. I think most agencies will tell you it took about 10 years to even feel like you're getting your feet underneath you in terms of operations. So if you're starting under a new law, you can expect that there's going to be some trial and error over that first few years. So you're going to need to have some time for a transition. Community-based visions, and proceed carefully and slowly. I'm just going to say a couple words about Jordan's Principle. Last week, I was in that hospital ward. The very ward where Jordan was in. Sisters were there too. Sometimes I hear people say the word JP. Please do not say that. This is a real little boy who gifted us Jordan's Principle. Jordan's Principle is sacred. And therefore, everything we do in Jordan's name has to be done in a sacred way. And we have to be very cautious about negotiating Jordan's Principle because of that. Jordan's Principle has got to preserve the spirit of the tribunal's orders and the spirit of the gift that this little boy gave to all of us. It means substantively equitable access to health, education, and social supports. What does substantive equality mean? Well, equality is the same as every other kid. Substantive equality takes into account that our kids are going to need more because of the disadvantages they faced. So they have the department over the last while, like I just want to say that it's been life-changing for so many kids across the country. Life-saving for so many kids across the country. And the department deserves some of the credit for that. But more recently, they have been breaching the orders with abandon. And they've been doing it they've been dropping policy without talking to anybody. On February 10th, they reintroduced this provincial buck passing measure. We're going to sit down with the provinces. It was never intended to cover provincial care services off reserve. Well, yes, it was. We have a legal order saying that Jordan's Principle applies to children recognized by their nation, regardless of residency, regardless of status. That order was appealed by Canada to the federal court, and they lost. So it feels somewhat like they're trying to achieve through these policy bulletins what the courts have already denied them. So when you saw that bulletin come out and Canada said, we're not funding educational assistance off reserve unless substantive equality applied, they put that in there so that you couldn't judicially review the bulletin. But what we found in an access to information request that has just made itself into our hands is that at the time when Canada dropped that bulletin, it had no definition for substantive equality. And if you go on to the department's website right now, that has been completely taken down, any reference to the definition or criteria on that. They've also written to the provincial governments, and to my knowledge, did not communicate that to regional leadership, that they want to sit down with the province and talk about Jordan's Principle. And I hear sometimes the minister and others say, we want to bring Jordan's Principle back to its true meaning. Well, I want to say, first of all, Canada's interpretation of the true meaning has repeatedly found to be racially discriminatory. So no thank you to Canada. The true meaning of Jordan's Principle is what is outlined in the tribunal's orders and what has been affirmed by his family. So, in general, we have got a bunch of proposals. You all know about the backlog, and I just want to say, I don't like that word because it's a dehumanizing word. Makes it sound like we're building cars and we just got a backlog of parts in the background. But I can tell you that within this last week, I know of at least 2 children who have passed on waiting. That's 2 kids. That's just me. Right? Canada is saying, oh, it's because of the volume that we're just too overwhelmed. Well, when it comes to tax season, I don't know how many of us in this thing have to file our taxes. But they deal with millions of it, and there's no problem. It doesn't say, Cindy, you can wait to file your taxes because we're too busy dealing with these other requests. Governments do that kind of thing. So we're saying that you created this backlog of cases, so the burden on it should not fall to children. When adults mess up, it shouldn't be kids paying the price. You should just have to approve all those cases and clean that thing up. And then you can start with some reasonable criteria on a go-forward basis. We want them to withdraw these discriminatory bulletins that have been refused even by the federal court. We want them to restore the funding for First Nations who are actually doing a great job with Jordan's Principle. And I want to put a special shout out to those people on the ground on Jordan's Principle, dealing with job insecurity, dealing with the front line, being able to see those families whose needs they can't meet. We got to stand with these people, as well as the people on the front lines doing child and family services. There are people doing the hardest work that's out there. So let's give them a round of applause. And we need to hold the department accountable in court, as Patrick Cully and his daughter Scarlett did, with the support of one of our lawyers, David Taylor. This is a case where a young girl was getting the help that she needed through Jordan's Principle, and then all of a sudden, oh, you don't need that much help that the doctors have said you need. You can make do with less, and it's only going to be time limited. Now, I don't know when the department officials became medical doctors, but they seem to there seemed to be something happening there. And so they denied it. And the family took them to the federal court, and the federal court agreed. The federal court said, you have to go back and redetermine this case. But something that Canada said was particularly concerning to me. The Charter of Rights and Freedoms got something called Section 15 in there, and that's to protect all of us from all forms of discrimination. Well, Canada is actually using that section to say, oh, well, we don't have to comply with Jordan's Principle. And the federal court has disagreed with that. So if you have any of these cases where they've said, well, there's a program available in a province, or there's a federal program that's available, or because of the charter, we don't have to deliver this service, that is not flying with the courts. Here's another important case. This is the Powless case versus Canada. You can see this beautiful grandmother looking after grandkids. These are beautiful children. They have respiratory issues, and they live in a house with mold. So one of the things that we do know is to keep a child in care who has no special needs. Now try to think of that, right? Because many of the children who go into care have come from traumatic situations, but let's just accept that, is $65,000 a year, okay? So these are multiple kids. To get rid of the mold problem is $200,000. Canada says, no, we're not going to pay it, right? The kids cannot stay safely in the home because of the mold problem. So it goes to federal court. Canada brings up this charter argument again, and they lose it again because it's in the wake of the Cully decision. But what is Canada doing? Well, they appealed that to the Federal Court of Appeal. And this case will be heard on October 6th. The Caring Society has applied to be an interested party, so is the Assembly of Manitoba Chiefs, which I think is great because, of course, Jordan River Anderson comes from that region. So there's going to be a bunch of really important decisions made by the Federal Court of Appeal on Jordan's Principle on that date. So keep October 6th in your prayers, and the Powless family. And, you know, I get that, you know, like you open up the news feed and that Trump is up to all kinds of problems, right? I don't know. He may not be an expert in being a good politician or economics or anything else, but getting into trouble and creating problems for everybody else, he's good at. And I get that the Prime Minister needs to focus on making the best use out of public funds. But violating legal orders and cheapening out on kids is not a good use of public money. And they should have learned this lesson already. Had they fixed the problem of the inequitable funding for child and family and Jordan's principle back in 2000 at the National Policy Review, it would have cost hundreds of millions of dollars to fix. That's not a small amount of money, but keep in mind, this is what kids were being shortchanged back then. At that time, First Nations kids were 6 to 7 times more likely to go into foster care. But Canada says, no, we're going to save ourselves some money. We're not going to do that. We'll kick in a couple million here or there, maybe do a couple pilot projects. And what happened to the kids? Well, the families became more traumatized, right? You saw it. The cost to support those families become much higher. And then when the case was finally substantiated, Canada had to pay out $23.4 billion to children who had been victimized, who never would have been victims had Canada done the right thing in the first place. Class actions make a lot of money for lawyers. Class actions do very little about stopping systemic discrimination. And I frankly never want to see another class action because I don't want to see any more victims. It's a waste of public money. I'd rather see this money reallocated for the government to do the right thing now. The solutions are on the books. Let's save everybody the money, and let's save, most importantly, these children, their childhoods, and their lives. That's the choice that the government has right now. And the message to Carney is it's not smart money to try and cheap out on kids. It's fool's gold. And I've seen a lot of fool's gold because I grew up in a very low income but hardworking family. And I remember panning up in northern BC and finding all kinds of gold. I thought I won the lottery, only to find out it wasn't real. So, and the other thing is that the best investment is in kids. And every dollar you spend on them saves a lot of money. It's not on someone my age. I'm going to be 61 on September 30th. And the best investment you can make for my birthday is to donate to a kid, because it's going to make a bigger payoff than to an old fossil like me. So what are the key messages? We need to, let me take the temperature of the room. Anybody here think we can't do this plan by December 20th? Let's give the kids a message. Let's say this to message to all the kids. Are we going to do that plan by December 20th? Because Canada's saying they're not sure they can do their plan by December 20th, but we're going to be delivering our plan by December 20th. Are we going to be standing with Joanne Powless on October 6th, and are we prepared to take any legal measures necessary to enforce the tribunal's orders so that our kids don't get hurt again? Are we going to use every opportunity that we have, from leadership and others, to have a direct conversation with the Prime Minister to say that we really want to come back in good faith? The question is, will you? And if you don't, there's going to be a lot of litigation ahead. And if you don't, it's going to cost you a lot of money that doesn't need to be paid. And if you don't, we still will. I never, ever thought I'd end up in a courtroom. Wasn't growing up to be a lawyer, just a social worker. But you know what I really realized is we can help some of the kids we're working with at the front lines, and those are sacred and important things. But by doing what we're doing all together and staying together, don't allow those divide and rule things, we can help millions of kids. Not just the First Nations kids, but all the kids. Because when our kids aren't suffering anymore, their kids aren't suffering anymore too. And I want every child to grow up proud of who they are. no matter if they come from an Islamic household or a Hindi household or what a Christian household. I really don't care. Proud and healthy kids are good for all of us. So you saw the work plan. We're going to get to it and get it out to you. You're going to begin having those conversations. We're going to get this plan done by December 20th. That means that leadership is going to have to organize to give the thumbs up to the plan, right, before we file it. Because we do have to file it even if people aren't organized. That's the other thing. So we're going to do our very best to respect everything, but we got a deadline to meet, and we've got to file this thing. The other thing I'm going to ask, one final thing, is that National Children's Chiefs Commission, isn't that amazing? How our people have organized across the country to do that work for nothing. And you know what? I think that deserves some financial support. It deserves our full support of those people who are sitting around the table taking time away from their nations to generously gift to all of us, and definitely deserves our financial support. So who's here with me of making a donation to the National Children's Chiefs Commission? Yeah, we can do this, right? Because we aren't going to let another one of our generations of kids go off and have to dream about the childhood they could have had. I want our kids to grow up dreaming about being an astronaut, the best artist, a great healer, maybe even being a fairy. But I don't want to have them dream about waiting for the adults to do the right thing for them. So let's make them proud. Let's hold that tribunal decision close to our hearts. Let's demand that Canada not appeal that decision, because they have until the 19th of September to do it. And let's never give up, because our ancestors never gave up on us. Thank you very much, everybody. Thank you. Oh, thank you, Ray.
It's a gift.
Thank you. Ray, thank you.